Welcome everyone, my name is Andrew. This is Article 6 of the National Master Contract. Today we are covering Article 6, Section 1, Extra Contract Agreements, Section 2, Workweek Reduction, Section 3, New Equipment, Section 4, Technological Change, Section 5, Hourly Training, and Section 6, Technology and Discipline. If you want to skip ahead straight to the reading, go ahead and click on the timestamp in the description. Below, you can find a link to the UPS Teamster contract, or if you have not already, you can also download the UPS Teamsters app on Android or the Apple Store. This app includes the contract with a handy search function that allows you to find articles and sections immediately important to your situation. I have also included a shorts link below to help you with installation. Article 6, just like Article 3, includes an important section to remember. I highly recommend that you listen to Section 6 until you can give a brief summary for yourself. And I say this because I personally know a few drivers who were able to recover their jobs after the use of Article 6, Section 6 as part of their grievance. Now, I'm not saying that the rest of this article is less important. Article 6 is loaded in the front and the back and should be a part of your recall during your day. Now, with the introduction finished, I would like to thank you for joining me today. I started this project a little over 2 months ago, and I have received many thank yous from my fellow UPSers in that time. I want to truly thank you. Your kind words really make my day. Now lastly, I will not do this often, but please do like and subscribe and share this channel with your fellow UPSers. Now, let us begin. Article 6, Section 1, Extra Contracts Agreements. Except as may be otherwise provided in this agreement, the employer agrees not to enter into, or attempt to enter into, any agreement or contract with its employees, either individually or collectively, or to require or attempt to require employees to sign any document, either individually or collectively, which in any way conflicts with the provisions of this agreement. Any such agreement or document shall be null and void. Any such agreement or document may not be placed in an employee's file or used by the employer as a basis for discipline or used in connection with any disciplinary proceeding, nor may any such agreement or document, nor the contents thereof, be divulged to any person or entity. In addition, the company will not discipline any employee for refusing to sign any company form related to the principle of a fair day's work unless the signing is required by law or by this agreement. Section 2, Workweek Reduction. If either the Fair Labor Standards Act or the Hours of Service Regulations are subsequently amended so as to result in substantial penalties to either the employees or the employer, a written notice shall be sent by either party requesting negotiations to amend those provisions which are affected. Thereafter, the parties shall enter into immediate negotiations for the purpose of arriving at a mutually satisfactory solution. In the event the parties cannot agree on a solution within 60 days, or mutually agreed extensions thereof after receipt of the stated written notice, either party shall be allowed economic recourse. Section 3. New Equipment. Where new types of equipment and/or operations, for which rates of pay are not established by this agreement, are put into use after the ratification date of this agreement, within operations covered by this agreement, rates governing such operations shall be subject to negotiations between the parties. This paragraph shall apply to all new types of equipment, including office and clerical equipment. In the event agreement cannot be reached within 60 days after the date such equipment is put into use, the matter may be submitted to the National Grievance Committee for final disposition. Rates agreed upon or awarded shall be effected as of the date equipment is put into use. Section 4. Technological Change. Subsection 1. Technological change shall be defined as any significant change in equipment or materials which result in a significant change in the work of any classification of employees in the bargaining unit or diminishes the number of workers in any classification of employees in the bargaining unit. Such changes could include, but are not limited to, the use of drones or driverless vehicles to transport, deliver, or pick up packages or platooning. Subsection 2. The employer and the union agree to establish a National Teamster UPS Committee for Technological Change consisting of an equal number of representatives from the union and UPS. The committee shall meet upon request, but not less than 3 times per year, to review any planned technological changes covered by this section. Subsection 3. The employer will advise the affected local unions and the National Teamster UPS Committee for Technological Change of any proposed technological changes when the changes has entered the field testing phase or at least 6 months prior to the implementation of such change, except where the change was later determined, in which case the employer shall provide as much notice as possible. In all cases, the company will provide notice of any technological change covered by this section before the technology is implemented. Subsection 4. The employer shall be required to provide the National Teamster UPS Committee for Technological Change any relevant information to the extent available regarding the technological changes. Subsection 5. The employer will meet with the National Teamster UPS Committee for Technological Change promptly after notification to negotiate regarding the effects of the proposed technological changes. The Technological Change Committee shall also have the right to raise and attempt to resolve any claim that the company's technological changes violates any provision of the National Master Agreement or the applicable supplement, rider, or addendum. If a technological change creates new work that replaces, enhances, or modifies bargaining unit work, bargaining unit employees will perform that new or modified work. The employer shall provide bargaining unit employees with training required to utilize the new technology if necessary. Subsection 6. In the event that the National Committee cannot reach agreement on the dispute, either party may refer all outstanding disputes to the National Grievance Committee for expedited resolution in accordance with the provision of Article 8 in order to determine if the employer has violated the provisions of the section or if the change will result in a violation of any other provision of the collective bargaining agreement. Subsection 7. This section shall supersede any supplemental, rider, or addendum provision on the same subject. Section 5. Hourly Training. Subsection 1. It is agreed that Teamster represented employees on a voluntary basis may train other employees. UPS reserves the right to choose to use or not to use Teamster represented trainers to fulfill its training needs. Subsection 2. Trainers shall be paid a 50 cents per hour training premium for each hour spent training. Subsection 3. Drivers, training helpers in accordance with the supplemental agreements, and 2. On-the-car rides for the purpose of route knowledge shall not be entitled to the training premium. Subsection 4. The parties shall establish a national training committee. The committee shall be empowered to hear and resolve any disputes that may arise over these issues. Unresolved disputes will be subject to the National Master Grievance Committee. Subsection 5. Each supplemental area shall meet and agree or continue existing agreements on the details of the application of this agreement in their area in accordance with the supplemental language. Other issues left for resolution at this level include, but are not limited to, the minimum qualifications for trainers, if any, the number of hours to be worked by the trainer, and the application of supplemental language concerning compensation for work performed in higher classifications. Disputes shall be resolved in accordance with paragraph 3. Subsection 6. Trainer selection and assignments to on-the-job training will be done in accordance with supplemental seniority provisions, providing the trainers have the necessary qualifications and skills for the job. Subsection 7. The training records that a Teamster represented trainer can be required to complete for drivers are those previously agreed to by the parties. If the employer wishes to amend these forms, it will first meet and agree with the National Training Committee. Such agreement will not be unreasonably withheld. No training record or verbal report by the trainer will be relied upon to discipline any employee or to evaluate any seniority employee's performance. Subsection 8. If a trainer is removed from the qualified list by the employer, that employee and the local union shall have access to the grievance procedure. If the union establishes that the removal was not for just cause, the grievant shall be reinstated. Subsection 9. No trainer shall be required to train in any method which violates the collective bargaining agreement. Subsection 10. Teamster represented trainers will not be permitted to perform or recommend disciplinary action. Subsection 11. Teamster represented trainers will not be required to make decisions or recommendations regarding the attainment of seniority by their trainees. The decision as to whether a trainee attains seniority will be made solely by UPS management. Subsection 12. Employees to be retained after qualifying in their classification and seniority employees scheduled for safety rides may request that a non-bargaining unit employee perform that training, in lieu of a Teamster represented trainer.
such requests will be honored. Subsection 13. Trainers will not be held liable for auto accidents incurred by the trainee. Section 6. Technology and discipline. No driver shall be discharged based solely upon information received from GPS, telematics, or any successor system that similarly tracks or surveils a driver's movement unless he or she engages in dishonesty, defined for the purpose of this paragraph as any intentional act or omission by an employee where he or she intends to defraud the company. A driver's failure to accurately recall what is reflected by the technology shall not by itself be considered dishonest. The company must confirm by direct observation or other collaborating evidence any other violations warranting discharge. The degree of discipline dealing with off-area offenses shall not be changed because of the use of the above-mentioned systems. No driver shall be issued a warning notice based solely upon the above-mentioned systems without first having a verbal counseling session on an identical infraction, for example, 2 seatbelt violations. Any such discipline shall also comply with the applicable supplemental disciplinary procedures and requirements. The company acknowledges that there have been problems with the utilization of technology in the past. Therefore, at the request of the union's Joint National Negotiating Committee co-chair, a meeting will be scheduled with the company co-chair to discuss any alleged misuse of technology for disciplinary purposes and what steps are necessary to remedy any misuse.